In a recent but not entirely unexpected development, a pivotal order has been issued by the South Carolina Court of Appeals on October 17, 2023, regarding the appeal of Alex Murdaugh's murder convictions. The Court of Appeals has temporarily remanded the case back to the circuit court level in Carlton County, where Judge Clifton Newman is expected to preside over this critical phase of the legal process. The decision follows a 6-week trial earlier this year, after which Alex Murdaugh was found guilty of the murders of his wife, Maggie Murdaugh, and younger son, Paul Murdaugh, on June 7, 2021. Immediately after the trial, Alex Murdaugh's defense team, consisting of Dick Harpootlian, Jim Griffin, Philip Barber, and Margaret Fox, announced their intent to file an appeal. The appeal, which was expected to focus on controversial admissibility rulings, was awaiting the delivery of court transcripts. However, according to Murdaugh's defense team, key developments brought forth additional concerns. Those key developments? Becky Hill, the Carlton County Clerk of Courts, released a book about her experiences during the trial, shedding light on critical interactions with the jury. Based on these revelations, Murdaugh's legal team filed a motion to suspend the appeal and held a press conference on September 5, 2023, announcing their intent to file a motion for a new trial. The recent order now allows for the submission of this critical motion. But what are the next steps in this legal saga? The state's response indicates that they believe an evidentiary hearing might be necessary to resolve the serious claims raised by Murdaugh's defense. Assuming the Attorney General waives a motion to reconsider, the next step will be the formal filing of a motion at Carlton County requesting a new trial. This motion is considered part of the post-conviction relief process. In South Carolina, the post-conviction relief process is a fundamental legal avenue for individuals seeking to challenge their conviction or sentence. Individuals can seek post-conviction relief by presenting various grounds that indicate a violation of their constitutional rights or a fundamental error in the legal process. There are a number of possible grounds for post-conviction relief. One of the most commonly utilized arguments is ineffective assistance of counsel. Some examples of this are inadequate legal representation during the trial or crucial errors by the defense. Constitutional violations are another crucial ground. If an individual's rights were violated during the trial, such as due process or illegal search and seizure, post-conviction relief may be granted. Another possible ground for post-conviction relief is misinterpretation or misapplication of the law during the trial, or a change in the law that affects the conviction. This can also be strong grounds for post-conviction relief. Murdaugh's motion for a new trial is based on newly discovered evidence, or evidence that was unavailable or unknown during the trial that could potentially change the outcome. That evidence? They are claiming they found evidence that the clerk of court, Becky Hill, made comments and implemented administrative actions with the intent of influencing the jury's verdict. Once Murdaugh's defense team files their motion with the circuit court, the filing will prompt Judge Newman to schedule a hearing to review the evidence and address the allegations of improper jury communications. During this hearing, Judge Newman will consider whether the allegations about improper jury contact are true and meet the standard for a new trial. If he finds merits in the claims made by the defense, it could lead to a new trial for Murdaugh. But the standards which Murdaugh's defense are required to meet are substantial. So let's talk about those standards. Murdaugh's defense must show the allegations in its motion are credible. If the allegations are deemed credible, they would then be reviewed using the proper standard. When the communication came from a court official, the standard is a communication to one or more jurors by a court official about the evidence that could have affected the outcome. So listen to that word carefully. I said could, not would. That could have affected the outcome. In a press release, Harpootlian and Griffin emphasized their intention to proceed expeditiously and seek a thorough evidentiary hearing. Stay tuned to FITSNews as this legal saga continues to unfold. If you're a fan of our work, head on over to FITSNews.com and hit that subscribe button to show your support. And make sure you follow FITSNews on social media to keep up to date on this crazy, never-ending legal drama.